In Southern California, I practice personal injury law. For those of you who don't know me, I do workers' compensation, I do personal injury, slip and falls, auto accidents, and today's discussion is about rideshare. I'm a rideshare attorney. I represent Uber and Lyft drivers who've been injured in automobile accidents. I represent passengers who've been injured in those accidents. I understand the insurance issues, and that's the discussion for today, the insurance issues for Uber and Lyft in California. I've been putting out a lot of content on this subject because it's a big subject right now, because Uber and Lyft drivers are currently categorized as independent contractors per Proposition 22, which is a proposition that passed by about 58% in California a couple years ago. That undoes what Assembly Bill 5 does for Uber and Lyft drivers, which is make them employees under a three-pronged test. The three-pronged test is a very simple test. It looks at different aspects of what they do, and it determines, is this person an independent contractor or an employee? Now, there are some aspects of being an Uber and Lyft driver that there is some freedom to do and work when you want to work, and the control mechanism is not super strong over an Uber or Lyft driver. But when Uber and Lyft drivers do decide to work, they are held to a very specific protocol on what and how they work. So this is a huge topic of debate. And in this live stream, we're going to go through the three-pronged test that makes Uber and Lyft drivers employees. And then we're going to discuss Proposition 22 and what's going on in the court system right now involving the constitutionality of Proposition 22. So Proposition 22 is... I hope that wasn't coming out. I think I might have been restreaming through Twitch. I got to go and make sure these are all muted. Proposition 22 is a proposition that basically undoes what the Supreme Court did when it found that Uber and Lyft drivers meet this three-pronged test to be employees under Assembly Bill 5. Assembly Bill 5, and we're going to bring that up in just a moment here, is a three-pronged test. And basically, the test consists of three different parts. And the first one is control. Control is whether or not an employer has control over their employees' duties. So if you're an independent contractor, someone hires you to do a job, let's say you're a plumber, you decide when to do the job, you decide how to do the job, you decide what parts to buy, and the homeowner doesn't tell you when to show up to work and doesn't exercise control over how you do things. You're the professional or the contractor, you're the contractor, and you decide how to do your job. Well, with Uber and Lyft drivers, you can make the argument that they're independent contractors because they decide when they're going to work, they decide where they're going to drive or whatever. Well, they don't really decide that because when the app is engaged by the Uber driver, and they decide to pick up a job, they're to go do that job, pick up the job, and they're to follow certain protocols. And Uber and Lyft actually assert control over how they do that work. So even though they don't have to show up to a job at a specific time, which is what an employee usually has to do. If you're an employee, your employer says, hey, you be here at this certain time, you do these certain tasks. These certain tasks have to be done this certain way. And if you don't do it that way, you're going to be terminated. Whereas an independent contractor just completes the job and gets paid, and they either meet the requirements of the contract or they don't. And if they don't meet the requirements of the contract, they don't get paid. They breach the contract. So there is the control mechanism. While some of those aspects of being an Uber Lyft driver do allow you to work when you want to work, and you don't have to show up to a 9 to 5, you ultimately do have to do things the way Uber and Lyft tell you to do them. So in my opinion, the control test goes towards being an employee. Now the other, the second prong of the test is whether or not the Uber or Lyft driver is performing work that's primarily outside of the course and scope of the employer's business. So if you're an employer and you have a plumbing issue, this is where we use the plumbing example again, you call a plumber, that's not the employer's normal business. Maybe they're an accountant, or they're a shop owner. They don't normally engage in the business of plumbing. So when they hire somebody to do a job to fix their plumbing, that's kind of outside of the usual course of their business, and that points towards the person who they're hiring being an independent contractor. But under this test, an Uber or Lyft driver is engaging in the primary business that Uber and Lyft are engaging in, which is transporting people. So it does that. The second prong of the test really does point towards Uber and Lyft drivers being employees, despite the fact that they're independent contractors right now. Now, many drivers do not have an independently established business or trade and rely solely on driving for these companies as their source of income, which indicates employee status. Independent businesses, having an independent business or trade means that you're able to do work for all different types of businesses and people, but they only really work for that one company. So they're not a plumber might go to one company and work, they might go to another company and work. And if you're working for all types of different companies, then you're probably an independent contractor. But again, an Uber and Lyft driver, they're only working for Uber and Lyft. They might work for both, but they're only working for those companies. And that points towards them being an employee. So under Assembly Bill 5, with this three-pronged test, it was analyzed by the courts in California, and Uber and Lyft drivers were found to be employees. But Uber and that decision was stayed, and Uber and Lyft moved in on this Proposition 22 and got it passed. And now Uber and Lyft drivers are independent contractors again. Well, it may be that this Proposition 22 is unconstitutional. An Alameda County Superior Court judge found that it was unconstitutional. It's now up on appeal, and basically says that Proposition 22 violates the legislature's authority under the California Constitution to enact a comprehensive workers' compensation system and define who is an employee and who's not an employee. In other words, AB 5 is an exercise of the legislature's authority under the Constitution to enact a workers' compensation system and decide who's part of it and who's not part of it, who's an employee and who's an independent contractor. So this is going to be something that we're going to hear about probably this year. Whether or not Uber and Lyft drivers are going to be employees or they're going to remain independent contractors under Proposition 22. Now, Uber and Lyft have a lot of power, and they're threatening that if Uber and Lyft drivers are reclassified as employees, if they have to give them workers' compensation benefits, if they have to withhold for employment taxes, that's just going to be too expensive and they won't do it and they'll just leave, which is kind of funny because Lyft is a California corporation. I believe they're headquartered up in the Bay Area. So they would leave the state that they originally started in, or at least where they're headquartered. So this is something that's coming up. If you're an Uber or Lyft driver out there and you've been injured and you caused the accident, you can't get workers' compensation insurance benefits. Or if you're an Uber or Lyft driver, you've been driving every single day because you're an independent contractor, you can't file a cumulative trauma, which is the type of repetitive work activity claim that an employee would be able to file to get workers' compensation benefits if they needed those to help them get better from an injury that they've developed over time. So the ABC test is a test under Assembly Bill 5. It found that Uber and Lyft drivers were employees. Then Proposition 22 comes in and reclassifies all the Uber and Lyft drivers as independent contractors. And now there's questions over whether or not Proposition 22 is constitutional or not, because it may infringe upon a constitutional power, and a proposition cannot do that in California. And that's where we're currently at. There was oral arguments in the appellate court last month, or in December actually, and there was discussion over whether or not this classification was going to change if Proposition 22 is unconstitutional. So if you're an Uber and Lyft driver out there, you may prefer to be an independent contractor. I don't know. That's not what this discussion is about. This is just a discussion from a rideshare accident lawyer. I represent people who've been injured in rideshare accidents. I'm a personal injury lawyer. I also do workers' compensation. So it's something that I'm very interested in seeing the outcome to, because a lot of my clients, I got Uber drivers, I got Lyft drivers, I got work injuries, and currently I'm seeing accidents where Uber and Lyft drivers don't have workers' compensation protections, and that's really sad because I do think that they qualify under AB5 to be employees, and there's been many who've made the argument, well, it'll be too expensive for Uber and Lyft. Well, corporate profits wouldn't be big enough, and that's really an argument that I don't really buy. I think that Uber and Lyft can make money providing their employees with the benefits that all workers get in California, all employees get in California. If you're an employee, you get workers' compensation insurance, which gives you a set of benefits. If you're injured at work, you get temporary disability payments while you're getting better from your injury. You get medical treatment to cure or relieve your injury. You get permanent disability payments if you have a permanent injury. You get a retraining voucher if you can no longer do your normal and customary job and your employer can't offer you a permanent modified position. You get mileage to and from your doctors. You get other benefits, including you can get a lawyer, and the lawyer is very affordable, and they can fight for all these types of benefits at the Workers' Compensation Appeals Board. So if you're out there and you're a worker, I can help you. If you're an Uber or Lyft driver and you didn't cause the accident and you've been injured, I can help you. If you're a passenger in Uber or Lyft, I can help you. And if you were injured in an automobile accident, but you're not getting workers' compensation insurance if you're an Uber or Lyft driver right now. So I don't know, is there anybody out there watching my stream? No, I'm looking here. It looks like I got a couple viewers maybe on Facebook and also on Twitch, but I don't see anywhere else, not on YouTube. I'm just really about to go home for today. I've been working all day. I have a lot of personal injury cases that I'm working on, and I wanted to put this up just to make sure that I'm keeping my page fresh, and I have a live going up that's discussing a relevant topic, and Uber and Lyft driver classification is very relevant for right now because there's going to be a decision soon, and the decision's probably going to be that Uber and Lyft drivers are employees, despite the gobs and gobs of money that Uber and Lyft have spent to stop that from happening, because let's face it, Assembly Bill 5 makes them employees. This also goes for Uber Eats and DoorDash and these other delivery services. Those are companies that are created to deliver products. They're in the business of delivering products. Their drivers are in the business of helping them deliver products. So they're not in an independently established business or trade. They're in the same business as the company they work for, and the company exercises a significant amount of control over those drivers. And those are the three parts of the AB5 test, making gig workers such as Uber and Lyft drivers employees, except for Prop 22, right? So Proposition 22 says no, we're going to take that back. Now, Uber and Lyft spent like hundreds of millions of dollars in order to convince the general public that they should that Uber and Lyft drivers should should be independent contractors despite AB5. Well, that's to save money. That's so they don't have to pay self-employment taxes. That's so they don't have to pay minimum wage. That's so they don't have to pay workers' compensation insurance. That's so that they can get a leg up on California workers and the California people in general. And it looks like that's probably going to be unconstitutional. So I will actually go into some more detail on my next stream about the specific court case and the different arguments and the different players. But for now, I'm going to sign off. I'm going to say goodbye. This was an interesting little test stream I'm doing here. I say it's a test stream because I'm just now getting into this live stuff. I'm trying to find a niche for myself. And I am a lawyer. I'm working hard all day. So, my content's going to be from a real lawyer working hard all day. I do think that Uber and Lyft should be classifying their employees as workers, and they should get workers' compensation insurance benefits if they're injured, because that's just the way that we do things here in California. If you meet the test, you should have to pay workers' compensation insurance. You shouldn't be able to get out of it by pumping hundreds of millions of dollars into the system to pass a proposition that overrides a worker's rights. I think that that's just wrong. So I hope that the good judges up there on the Supreme Court think the same way as I do. I'm putting this up here because I want to influence the public to some degree, and put this out here that I also help rideshare in accident victims with their personal injury claims. So if you've been involved in an accident, you're going to have multiple different insurance issues. You're going to have your own insurance. You're going to have the driver's insurance. You're going to have maybe the insurance of the party who hit you. Maybe they don't have insurance. You might have an uninsured motorist claim. You might have an underinsured motorist claim where someone hit you while you were a passenger in an Uber or Lyft, and there's not enough money to pay for all of your medical costs. Well, Uber and Lyft have uninsured motorist bodily injury insurance, which is another topic for another day. I could do a whole stream just on that. That's a specific type of insurance that will protect you, that Uber and Lyft purchase if you're a passenger or a driver. You're hit by an uninsured motorist. It's not your fault. You get injured, and you can claim and make an uninsured motorist claim on Lyft or Uber's insurance policy. Now, that's some super shady business. I've been dealing with some of that. They don't want to pay. Not only is Uber and Lyft pressuring the government to not find their workers as employees in order to avoid all the things that payments and things that I've just discussed. Well, they provide insurance. We provide uninsured motorist coverage, but then they lowball you on these policies a lot of the time. So you end up having to arbitrate them. They end up not wanting to give you any information about the policy. So if you're out there and you've been involved in an accident, you're not getting any information from Uber or Lyft. They're giving you the runaround. It's time to call a lawyer. It's time to get aggressive, because the same type of crap that the Uber and Lyft are pulling on injured workers, they're pulling on you too when it comes to their insurance. So with that said, I'm going to sign off for now. I'll be back tomorrow with a little bit more of a coherent conversation about this. I want to go into more detail on some of these issues. And yeah, have a